you please be seated now?
This is the court may upon finding complaints or
Good morning, I'm Judge Clark, and we're here for VOP and Motion Day. And I see Mr. Garrett and Mr. Lupella.
Chris gives on it. You got our person on the list. We're still working on the complete sentencing agreement, so pass my case briefly, please.
All right. Mr. Lupella, are
We
you?
also, I'm trying to verify restitution.
All right, so Ms. Farkas.
Your Honor, I believe I have one client who's present in the courtroom, unless Mr. Harper is ready to go. My client does have a very small child with her, so it wouldn't
Why don't
probably
we
be bad to
take,
address.
let's take your case.
Lachey Cooper?
All right, this is 23 CF 1557, and Ms. Cooper is present.
Yes, Your Honor. Lachey Cooper, she's here on a VOP. I've been speaking with Ms. Gaynor and with Ms. Cooper's probation officer about her case. There have been a couple updates. I believe that the state and I would both like continuance to the next VOP date. I know that it's been continued a couple times, which is a little odd for a VOP, but there are some extenuating circumstances. Would be happy to approach if Your Honor would like some more information.
Let me see what the state's position is.
Your Honor, Ms. Farkas did inform me that I don't have an objection to a continuance.
Okay. So,
The state will be in a position the next court date that it'll set a VOP hearing if there is not a negotiable plea.
just wasn't looking.
That is fine with the defense. We are also planning to have a negotiated plea at the next date, so.
okay, because I have it down from September 16th. That was our last court date, that was the last time.
Yes, Your Honor. It's based on additional information from the probation officer,
Okay.
and we're kind of letting her
I did
read the-
review, I did review the recommendation, and it was updated.
Yes.
So, okay.
Thank you, Your
In
Honor. I
light
do
of
appreciate
that, then our next date is November the 18th.
Thank you.
November 18th at 9 o'clock, and we need to resolve it.
No, I'll come talk to you right now.
It either needs to be resolved at that court date, or
Yes,
we
Your
need to
Honor.
have an evidentiary hearing set.
I think that's my only client who I see here right now.
Okay.
Most of mine are in custody.
I see Mr. Nopes present. Mr. Nopes, are you ready? And I see Mr. Durrell too. So whoever's ready.
Judge, I've only got one case, Pamela Henson.
Okay. And,
It's just stats, Your Honor.
yes, that is case 23 CF 818. And is Ms. Henson present?
Judge, I don't see her when I walked in. I was looking for her. I don't see her. Maybe wait, if we could wait.
Pamela Henson, are you present? Okay, here she comes. And Ms. Henson's present. All right, we're here for a status on outpatient competency restoration. And where are we on that?
Judge, I think she's meeting with the person that's been assigned to handle the matter.
Okay,
If I can speak so real quick. Shortly after my release, I immediately went to somebody because there was some underlying issues. And so I have been going since September 11th of 2023 but I haven't had a consultation with an attorney as of yet. No, not even Rudy Harper. And I was on an ankle monitor. They're saving the data because Rudy says that I came to his office. Well, I never did. I've been through 3 attorneys, and I haven't even had a consultation yet. We're 3 years into this, and I'm begging for depositions for 3 years now, having nervous breakdowns over depositions and lack of counsel.
Okay, just one second. So, Mr. Nopes, do we have any reports?
No, no, ma'am.
Who-
I checked the clerk's website, and
Yeah, I
I don't
did
see
too.
anything that's been filed.
Oh, that's the other issue. When he stated when we were in court the other day that he had contact me on email, he never has. And
Hold on
as-
just a
hold
second,
on.
ma'am.
I had to come get the court order on September 18th so that I could follow your directive. I haven't even been provided the court order by my attorney. I wasn't even
Just one
prepared
minute,
for
ma'am.
last time's session.
Let me speak to your attorney for a second and try
Okay,
to
yes,
figure out
ma'am.
what's
My
going on.
apologies.
So, Ms. Belancier, I think, was going to do this restoration, and she's no longer,
Oh,
it's my understanding, she's no longer she's no longer in that position.
oh, wow.
So, who
Who's the new person?
I do not know. I don't know if there is one. So, which assistant state attorney is on Ms. Henson's case?
That's me, Your Honor.
Okay. So I'm wondering who's doing the restoration, or is the restoration happening?
We do not have word on who would be doing them now.
I have been going to Lakeview.
So,
So you were seeing someone at
At
Lake?
Lakeview since September 11, 2023 on my own accord. I didn't need the court to tell me. I was needing to go. There was a medical issue. I was hospitalized a couple of times. My brain had swelled.
all right, this is a separate mental health professional that you're supposed to be seeing, but it's not your fault because.
No, I've tried to call, I've reached out, sent emails, and I'm just at a loss. I'm getting well enough now physically. I've been being remotely monitored at this point by the endocrinologist out in Destin. I'm barely able to stand up here. And
you'll
I've
just
been
hold on.
coming every court hearing. I've not missed a court
I
hearing yet in
know.
3 years.
I appreciate that. So, Mr. Nopes and Ms. Giardina,
Judge, I guess I could contact court administration and ask who's in that position now?
I don't think that is a person who's
No.
provided by court administration.
I went over the documents and I couldn't locate anything. It said that someone would be reaching out to me, and I've already called them, and I can't get through unless I'm making a complaint on someone's well-being. So, and I've tried every number, and I'm from here. I'm unable.
So the problem is the county had a person, a mental health professional who would have been handling this issue, and it's my understanding that that person is no longer in that position.
So Gabrielle,
Belancier,
is that how you pronounce it, I guess?
I think so.
So she's no longer,
It's my understanding.
so I need to find out who took her position.
So, just check one other thing.
I've come through circles trying to find information already.
Is this a situation where mental health pretrial services might?
Me and Lorenzo I have been seeing him once a week, and I'd really just prefer to go back there and continue with Lakeview, and they can get reports from Lakeview, if that's possible.
Okay,
I have a very good rapport with Lorenzo.
let me see. what-
And mental health, that is a great tool to use, the best one actually that's available. If you need some help or anything, he's right there. You have a question, he's right there. You need your court date, he's right there.
Okay.
Judge, I'll contact Lorenzo.
See,
Maybe he might know.
He was monitoring me a month longer than I was court ordered because of the holdup in receiving the court order last time, and nobody even informed him. And we were continuing. So there has been supervision this whole time.
just bear with me, ma'am, I'm just looking for something.
Yes, ma'am.
Your Honor, Ms. Balsao is actually reaching out to someone right now who deals with Lakeview to see if
Ms.
they can give
Kim.
us a recommendation.
Miss Kim is who I see. And my next appointment is November 4th at Lakeview with Miss Kim, and I can give you contact information to her. I can email it to you.
That'll be fine.
Okay, so it looks like in 2023, Ms. Henson was placed on pretrial services.
Yeah, I wore an ankle monitor for over a year, finally got that off
Right.
after Lorenzo told me to, you know.
And then from what I can tell, that is still ongoing. Ma'am, do you still meet with Lorenzo?
Yeah, absolutely. We have
Okay.
a very good rapport. That is a good tool to use in pretrial services. They're not there to harass you in that. They are actually a good tool for whatever services or whatever questions you might have.
Okay. So,
That way I can have somebody to report changes to, because, you know, I'm court ordered. If I move, if I want to leave to go on vacation, I have to have your approval. And I haven't been anywhere in 5 years now, and over 3 of them were because of this. I'm still on a $1,000 cash bond, where when it's completed, I get my money back.
well, we're on hold right now.
I know, I understand
Yeah,
that.
the
We
case
have
is
to
on
do what needs to be
hold
done.
Pending meeting with a mental health professional for competency restoration. And that was going to be on an outpatient basis, but somehow that has gotten stalled out because the person who was going to provide, wait, don't interrupt, please. The person who was going to provide those services is no longer in the position to do so. So I don't know if this is something Bridgeway can do. Did Ms. Paso find out
He
anything?
did not pick up the phone.
I left a message, ma'am, and I also sent him an email, so if I hear something back, I'll
Thank
advise
you.
the court.
Thank you. What we need to do is, wouldn't this be a DCF matter?
I'm sorry?
Wouldn't this be a DCF matter? I mean, DCF is in charge of competency restoration. It's just the setting that that occurs in.
Right.
So, let me find my order. Okay, what I need to do is I need to send my order that I entered on August 4th to DCF. And let me just make a few notes of what needs to happen. I think my order, it was the order adjudging defendant incompetent to proceed and placing defendant on conditional release entered on August the 4th. That was following our hearing, I believe, in July.
Yes, ma'am.
And that order needs to be sent to DCF. And I probably need to enter a separate order that says I'm ordering DCF to provide services on an outpatient basis and provide reports to the court. So why don't we set Ms. Henson for the November court date? That would be November 18th at 9. And that'll be a status
That'll be fine.
on restoration.
And I should be looking for someone to be reaching out to me then?
No, ma'am. What you need to do is make sure that, let's make sure that Mr. Nopes has your contact information,
You did good.
and so that he can get a hold of you. And then the court and Mr. Nopes and the state, we're going to try to get DCF involved to provide somebody for you to meet with, to do this restoration program through mental health.
Yes, I'd like to expedite it as quickly as
Yes.
possible.
Okay. Madam Clerk is informing me that the clerk sends those orders to DCF
Oh,
anyway, but there's been
I had to come down and get a copy on
no
the 18th.
action taken by DCF.
when you say DCF, I mean, is it some local representative?
We have an email group where it goes to DCF and competency orders, along with the two individual people as well.
Wow.
So it's interested in entire
It sounds like well, I guess that didn't order them. Well, but I think the order suggests that it,
Let me see what it says. It mentions a case manager, and that would have been Ms. Balancier, most likely.
yes, so her title was Forensic Mental Health Specialist, Okaloosa, Walton County.
Okay, so I need to do something to follow up with DCF. Can you tell in your system that that particular order was definitely sent to DCF? Because I only had Ms. Balancier this week.
Yes, ma'am. It's going to show on the chart that it says it's supposed to be the state that is submitting competency orders, which is the email. I was actually going to be specific emails that goes to.
Okay, so Madam Clerk has confirmed that this order did go to DCF, and I need to follow up and figure out what's going on. And perhaps do an order, an amended order, requiring DCF to provide these services, because that is their purview. So for now, Ms. Henson, we're setting you for November 18th at 9, okay?
I got it written down.
Great, and I'm going to follow up in the meantime to see if we can get things going with
Thank you so
providing you with a mental health counselor that can meet with you and do the competency restoration. It's a specific type of services that need to be provided to you, okay?
Yes, ma'am.
All right.
Thank you so much.
Thank you.
Thank you, Judge.
Thank you. All right, I see Mr. Durrell, Mr. Lupella. Okay.
Mayor, I have two cases today. Both are inmates. First is Mr. David Archer.
Okay. That is 23 CF 166.
And Your Honor, the state and Mr. Archer has reached a agreement in this matter as far as the violation goes. I just need him to sign it.
Okay. All right, the defendant is present.
You're right. Thank you very much. If I may approach, Your Honor?
Yes, thank you. Thank you so much.
My handwriting can be a little rough. If I may, if you want me to announce, I can, Your Honor.
That'd be,
Yes,
yes,
Your Honor. At this point, Mr. Archer would enter a no contest plea to the admission and admit the violation with the understanding that probation will be revoked and terminated, will be sentenced to a fresh 1129 sentence in Okaloosa County Jail. He will be granted credit for time served from September 1st of 2025 and forfeits any remainder credit for time served. $100 BOP fee. Any other outstanding financials, we are asking, I believe I put 90 days from the date of release to pay.
all right. And was Mr. Archer previously adjudicated guilty on the underlying charge?
I believe he was, Your Honor. Yeah, he tells me he was.
All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, sir. If you could please state your name.
David Joseph Archer.
Thank you, Mr. Archer. Your hearing case 23 CF 166. There was an affidavit of violation of community control filed on August 27th. It had 2 allegations that you violated your community control. Have you had a chance to review that affidavit and those allegations with your lawyer?
Yes, ma'am.
Right. Have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the second page?
Yes, ma'am.
Do you understand you're giving up your right to have a contested hearing and make the state prove the allegations?
Yes, ma'am.
Are you entering the admission freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
All right, I do have a score sheet that shows 40 total sentence points. Any objections or corrections?
No objections, Your Honor.
All right, sir, are you admitting to both of the allegations that you violated your community control?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given. In accordance with your agreement, probation or community control rather will be revoked and terminated, and you are sentenced to 11 months and 29 days in the Okaloosa County Jail. You'll get credit from September 1st, 2025, and in accordance with your agreement, any credit before that would be forfeited. There's a $100 VOP fee, cost of prosecution fee, and that's in addition to any previously assessed fees and costs. You'll have 90 days after you get out of jail to pay all of your outstanding fees and costs. Did I cover everything?
I believe that's everything.
Okay. And sir, you'll have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck to you, sir.
Thank you.
Thank you.
You'll want to wire it next?
All right, this is case 22, CF 2711, and the defendant is present.
Yes, Your Honor, we are asking for a continuance of Ms. Dwyer's case. This is Mr. Cody Sprouse's case. It's my understanding he's out with a injury at this point.
Okay.
Your Honor, Mr. Sprouse had requested to set this for a VOP evidentiary hearing.
Okay.
I believe that's fine, Your Honor. We'll either have it resolved or be ready for the hearing.
All right, so how long does Mr. Sprouse need?
An hour?
An hour?
Yes, Your Honor.
Let's see what we have. All right, what I might need to do is have Amanda provide some dates to y'all to schedule it, because I mean, I
Our
have
office
dates.
will reach out to Ms. Bailey, and then we'll get a
Wonderful.
date. Perfect, thank you.
That is great, because if I try to schedule it, I'm going to
Absolutely.
schedule over something, so. Let me go ahead and set the next date of November 18th, just in case, because I don't know when that evidentiary hearing will be scheduled.
Understood.
So, November 18th at 9 o'clock, and I'll make a note, the state will reach out to set that hearing.
Thank you very much.
Thank you. Thank you, ma'am.
I believe that's all I have. If I may be excused.
Yes, have a great day.
Thank you, Your Honor.
Mr. Snell,
Yes, ma'am. How are you today?
great, how are you?
Good. I am here for the state in versus Lacey Sutton. She has 4 cases before the court, Your Honor.
Okay,
The last time that we were here, we continued it till today for Ms. Sutton to make the full restitution payments for case numbers 2019 983, 984, and 985.
okay,
That restitution payment has been paid. It only leaves restitution for the 19 CF 2905, and Ms. Sutton has already in a payment arrangement that's monthly payments. So and there's outstanding court costs as well. At this time, the state would ask the court to dismiss the violation of probation and terminate the probation in all 4 cases. Send the outstanding restitution in the 2905 case to a civil lien, as well as the court costs, Your Honor.
okay. And Mr. Lupella?
That's fine, Your Honor. I think she's already, I don't know if the civil lien is necessary because it's already working as a garnishment. I don't know if we have to do the civil lien on top of everything else, but the money that she owes to the state is being garnished from her checks. So that mechanism's already in place. I don't know if we need to add anything to it, but that's up to the court. Otherwise, we have no objection.
All right, so as to the 2019 983, 984, and 985 cases, would that be a successful termination then?
Yes, ma'am.
Okay,
There, like I said, there are court costs still associated with those 3 case numbers,
okay,
but we would like that to just go to a lien with the restitution on the other case.
all right, let me get some input from Officer Profit. about, would this be a successful termination even though she still owes court costs, or how do we handle that from probation's point of view?
I guess we could do a revoke and turn, or just dismiss the VOP, she
Okay.
terminates. We place the court costs in the three cases in civil lien.
When I spoke with
So there's a mechanism in place for
The other one?
Officer Meggs, felt like she had substantially completed her probation,
Yeah.
and that's why I announced it the way. That's the impression that I got from probation, that she had done quite well, as best as she could, so.
Okay, so would the VOP be dismissed in all 4 cases then?
Yes, ma'am.
Okay,
She's, according to Officer Meggs, she was doing everything in her power to get everything paid in the 5-year period of time she's been on probation, so.
yeah. Thank you for taking probation seriously.
Yes, ma'am.
Thank you. So, in that case, excuse me, is the state announcing a dismissal of the VOP in all 4 cases then?
Yes, ma'am.
Okay. And then we will send all the court costs to a civil lien. Ma'am, that's going to affect your driver's license. If you need a payment plan, you can talk to the clerk. Mr. Lupella, do you need a certain period of time before it goes to the civil lien?
I generally don't deal with that in my representation with the client.
Okay.
As far as, I do recall, and Mr. Durrell, I don't know if he's here. I do remember a conversation I had with Judge Stone at a bar meeting where he said that issue was fixed. Whatever, in regard to driver's licenses getting affected by civil lien issues. So I don't know.
Or actually be collections. I
Or
think.
collections, or however it works, where it doesn't affect their driver's license. I thought Judge Stone had addressed that issue with the clerk and whomever else, but
120 days to pay.
I mean, yeah, that's fine.
Okay. Let's say the outstanding court costs will go to collections after 120 days. You can go see the clerk and get on a payment plan.
Okay.
And that might help prevent your driver's license from being affected.
Okay, thank you.
Yes.
That should conclude Ms. Sutton's business today.
And the dismissal of the VOP will not affect the garnishment in 2019 CF 2905. That would continue.
Of course, Your Honor, yes.
All right. Anything else I need to address? Let me check. Is probation terminated? I believe it is.
Yes, yes, it is.
Yeah.
Yes, ma'am.
So,
That's the
all right.
intention, yep. Yes, ma'am.
Thank you, ma'am.
Yes,
Good
ma'am,
luck to
thank you.
I've got 2 other cases, Your Honor. I can
All right,
address.
Mr. Lutella.
The next is Gregory Cofield. Mr. Cofield's present and approaching.
Okay.
There he is. I've got a written plea to tender.
All right. Thank you very much. Okay.
Is Mr. Cofield before the court, Your Honor? He's here on status. The status on the violation of probation on 23 CF 612 at this time. We've reached an agreement with the state in which he would enter a plea of no contest, admitting the violation of probation. Pursuant to our agreement, his probation would be reinstated, original terms and conditions and original termination date, and the standard costs, court costs and violation fees would apply. And like I said, all conditions that were previously imposed would be reimposed, and he would just be basically back on probation. And in doing so, we would ask the clerk to cancel the evidentiary hearing that was set for this matter. It was set on 11/13. And I can file a notice of cancellation if that would be.
Yes, Because that
requirement.
one, I think, was special set by my
Right.
office. So if you
Okay.
would, please file a notice of cancellation and send a copy of it to Amanda so she can take it off the calendar.
Very good.
All right, so let me go ahead and swear in Mr. Is it Caulfield or Cofield?
Cofield.
Cofield. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. You're here in case 23 CF 612 on allegations that you violated your probation. Have you had a chance to talk to your lawyer about those allegations?
Yes, ma'am.
Did you discuss this plea agreement with your lawyer?
Yes, ma'am.
And did you read and sign it?
Yes, ma'am.
Is that your signature at the top of the back page?
Yes, ma'am.
Do you understand you're giving up your right to have a contested hearing and make the state prove the allegations?
Yes, ma'am.
Are you entering the admission freely today?
Yes, ma'am.
Is anyone forcing you or threatening you?
No.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Are you admitting the allegations that are contained within the violation of probation affidavit?
Yes, ma'am.
All right, I accept your admission. I find it was freely and voluntarily given in accordance with your agreement. Now, was adjudication previously withheld?
No, ma'am, it was not.
Adjudicated?
That is
All right.
correct.
All right, so probation will be reinstated under the original terms and conditions. So whatever you have not already completed, you still have to do. And original termination date will be in effect. And I believe the only court cost would be a $100 cost of prosecution. That's in addition to previously assessed court costs. So,
Defense will stipulate to that amount, Your Honor. Thank you.
thank you. All right. And you have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. And good luck to you, sir.
Thank you.
Thank you.
Thank you. All right. I have one last matter on the docket, Your Honor.
All right.
Can I jump in real quick?
Go ahead.
Mental health referral services, Kelly Wastek reached out to me, apparently they have hired somebody to replace that person. They were hired yesterday, their name is Nicole. It should be pretty quickly to get them rolling. So just so the court's aware, they've handled that issue.
Mr. Gates, thank you so much. This is on that previous case for Mr. Noakes.
Yes, sure.
Thank you.
Yes, sure.
Make a note of that. All right, sorry about that, Mr. Lupella. You have one more case on the docket. Is that
Yes.
Joshua Prince?
It is, Your Honor. It's 21 CF 2059, and it's on a motion to withdraw.
Is Mr. Prince present?
He is not present, Your Honor. We've had difficulty locating Mr. Prince, and that's part of the reason why we're withdrawing, lack of communication.
So I looked at this case last night, and I am puzzled. And which assistant state attorney is assigned?
It's mine, Your Honor.
Okay.
I did notice a bond.
So here's, sorry, go ahead.
No, I did notice, Your Honor, that there was a bond given on a VOP.
Yes, I'm.
It's not a VOP.
Well, it's an open case.
It's open case. Yeah.
From 2021. It looks like it was direct filed. It was transferred from county court to circuit, and there was a direct file. From what I can tell from looking at the file, Mr. Prince was arrested and served with that direct file because, Mr. Lupella, it looks like you filed an emergency motion for a bond stating he's in jail? You didn't?
No, it was set prior to him being served with that felony warrant.
Okay, because I
Right.
thought your motion said he was in jail, but let me
I don't think
just
so.
pull it up again. I'm not sure whose phone that is, but it needs to be turned off. Okay, so I'm looking at your motion again. For some reason, I was thinking he was in jail when you filed it. So we don't know that he's ever been served with the capias, is that?
It's not a capias.
Well,
It's a warrant.
The warrant.
I mean, I guess they're interchangeable in a sense. It's not because he failed to appear or violated probation, though. It's a new charge.
It was upgraded from county court to circuit court. The state filed felony charges, issued a direct file capias. Do we know whether he's been served? I could not tell from the court file. Doesn't look like he has.
No, because if he was served, then he would have been picked up and then subject to having to post bond to be released. I can let the court know that we've provided notice, proper notice to the defendant at the last known address. As far as our motion to withdraw, we've had contact with his family to try to locate him and not been able to do so. So I think we've done everything we need to do on our end from a defense standpoint in order for the court to feel good about granting the motion to withdraw. Then I would suggest that the court I think there's nothing else for the court to do. It would just be that the warrant would be outstanding and he'd have to either be turned in on that warrant himself or he's going to have to be arrested and then he'll have to answer to these charges. So it's just a little awkward because there is a case number assigned, but it's because of the fact that there's a certain awkwardness in the fact that in this state we have it's kind of an odd thing that the state can file a direct file capias and then basically create a new case. Due process notwithstanding, if a person's already had a bond set and then with the same facts and then the state says that the charge is worthy of a felony, then that initiates a new due process consideration. So that's neither here nor there, but I think that the only thing for the court to do would just be to grant our motion and then nothing else.
Okay. So let me hear from the state. I mean, I was thinking that this warrant had been served, but apparently not.
I mistakenly was assuming that as well, just reviewing the court file. But it doesn't look like he's been served on that warrant. I don't think we can do anything until he is, unfortunately. I'm not going to have any objection to Mr. Lapilla's motion today as far as that goes, but I don't think we can do anything on the case until he's served.
Okay. I'm granting your motion. Could you please provide me with an order, Mr. Lapilla?
Yes, should have been sent with the motion, but
it may have been. I've been in court all day yesterday. I haven't.
That's fine.
Been able to look for it.
We'll get it sent to the court.
If you already sent it, then it's there. I just didn't know you'd already sent it.
I will double check as soon as I get back to the office.
Okay, that's great. Thank you, Mr. Lapilla.
Thank you, Judge. That's all I have. If I could be excused.
Sure. Well, before you do, let me ask the PD's office. I guess since I'm granting Mr. Lapilla's motion to withdraw, if there's an outstanding warrant, I guess we need to wait until he's arrested and then appoint the PD, correct?
Yes, sir.
Okay.
Only if he's determined to be indigent would the court consider
obviously,
that.
yes.
At this point, I think what the court has in front of itself is the probably presumption that he's not indigent because he hired private counsel previously. So I don't think that would be premature. But I'm off the case, so I'm not involved in that discussion. Thank you, Judge.
There you go. Thank you. I've got Mr. Garrett, I've got Mr. Catalinic.
Your Honor, we'll put it on a score sheet.
Okay, Mr. Catalinic, are you ready?
You can pass me, I still need to talk to the state for 5 minutes.
Okay. It looks like I've got Mr. Harper present.
Judge, I have a couple applicants.
That would be great.
Judge, I'll pick this up with Roderick Alston, number 15 on the docket. Judge, I'm going to ask to move this to another miscellaneous date. The court may recall, there's a waiver appearance. The court may recall this is going to be a plea, client's amenable. There's some health considerations that make it problematic for him to appear, so we're trying to do this by Zoom. I was not able to get confirmation from he's got a third-party caregiver that I've encountered some difficulties in communicating with her. But if I can move this to another court date, I can get this resolved. My client's amenable to the terms. It's just court costs and time served, but I just need to, logistics was an issue, Judge, so.
Okay. Let me see what the state's position is.
Alston? I'm just going to send it to you tomorrow. Okay.
Just real quick. Your Honor, can we approach?
Yes.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right, so what we're going to do for Mr. Alston, 24 CF 715, I'm going to set him on November 18th at 9 o'clock. That would be for a change of plea. But I'm also going to set December 8th at 9 o'clock for pretrial. Now, if, Mr. Harper, if he's not going to be able to complete the paperwork and get it back to you in time for that November 18th court date, please cancel it.
Yes, ma'am.
And we'll just have the December 8th date. It's already scheduled. The November 18th is conditioned upon him, you getting him the paperwork, him signing it, and him returning it to you in time for that court date.
Yes, ma'am. And I'll reach out to your JA to get the Zoom facilitated.
Okay, great. Thank you.
I have two additional out of custody. First one is Jacqueline Bruce, 25 CF 787.
Yes.
She is present and approaching.
Yes.
Judge, this is... Judge, this is a PTI. It has been signed by the parties. I provided a copy to probation, if I may approach.
Yes.
Mr. Harper, do I need to sign that?
Ooh.
Oh, yes.
That's perfect, thank you. Thank you, ma'am, for coming back today. I know you were here yesterday.
No problem. Thank you.
If I may approach, Judge.
Yes, thank you. So this is without a plea, is that right?
That's
Okay,
correct.
Thank you. All right, ma'am, if you'll just raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. You can put your hand down. And in case 25, CF 787, your current charge is one count of child abuse without great bodily harm. Have you had a chance to talk to your lawyer about that charge and any possible defenses?
Yes, Your Honor.
All right. I've been handed a pretrial intervention agreement. Did you read this agreement, ma'am?
Yes, Your Honor.
And is that your signature on the back?
Yes, Your Honor.
Thank you. So this is a golden opportunity. If you comply with the program, you meet all of the terms and conditions, you don't have any new charges, you don't violate any of the terms or conditions, then after a period of 12 months, then the state will dismiss the case against you. If you do have a violation or pick up a new charge, or you don't complete all of the terms and conditions, then the state will proceed with the charges against you. Do you understand that?
Yes, Your Honor.
All right, so I have received this agreement. It appears to be signed by the defendant, as she stated, and the state and probation. I'm going to hand it to Madam Clerk. And Officer Prophet, does she need to meet with you now?
Yes, ma'am.
Okay, so meet with Officer Prophet, and then you'll leave the courthouse and go straight to probation to check in.
Yes,
And good luck to you, ma'am.
Yes, thank you.
Thank you.
The next one I have, Judge, is Stephen Davis before the court on 24 CF 2952.
All
He's
right.
present and approaching.
All right, great, thank you.
And Judge, this is also a PTI. The only difference in that, and I spoke to probation about this, if the court would permit, because he had to come back today, he's having some work difficulties. He's asking if he can report to probation tomorrow morning. Probation's okay with that, if the court is okay with that.
Let me make sure the state's okay with that.
The state's fine with that.
Yes,
We
that'd be
prefer that
fine.
he be able to work.
Yes, thank you. And this one is without a plea as well, correct?
That's correct, ma'am.
All right. All right, Mr. Davis, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. If you'll state your name for me, please.
Stephen Davis.
Thank you, Mr. Davis. In 24 CF 2952, you're charged with one count of child neglect without great bodily harm. Have you had a chance to talk to your lawyer about that charge?
Yes, ma'am.
Did you discuss the pretrial intervention agreement with your lawyer?
Yes, ma'am.
Is that your signature on the back?
Yes, ma'am.
All right. Sir, this is a wonderful opportunity. You may have heard me speaking to the case ahead of you, that if you comply with this agreement, you don't have any new charges, you don't violate any of the terms or conditions, and you complete everything that's required, then the state will drop the case against you. They'll dismiss the charge. If you do pick up a new charge, or you don't complete everything in the agreement, or you have a violation of any of the rules, then the state's going to proceed with the charges against you. So good luck to you, sir. You'll need to see Officer Profit before you leave the courtroom, and then check into probation first thing in the morning, okay? Before 9 o'clock. All right, good luck, sir. Thank you.
Judge, those are my out of custody. I do have some inmates, but I'm fine with clearing out the rest of the courtroom.
Okay, let me go ahead and take, let's see if Mr. Garrett is ready.
You got, we're still getting the score sheet together.
Okay. I'll take some cases without attorneys. Do I have Tommy Alberti present? And these are case numbers 24 CF 1305 and 24 CF 1711. Yes, I'm Judge Clark. Can you state your name, please?
Tommy Alberti.
Thank you, sir. You're here on an order to appear that was issued by me for some allegations that you violated your probation. And I see that you don't have an attorney at this time. Would you like me to appoint a lawyer for you?
Yes, ma'am.
I'm appointing the Office of the Public Defender.
Your Honor, I've represented Mr. Alberti in the past. He does need to do the public defender application. Does the state have an offer?
Not at this time.
Your Honor,
okay.
If we could just move him to a VOP hearing without subpoenas, he'll enter a denial today.
Okay.
And then
No VOP.
Is this a VOP?
It is. It's cost of supervision, drug test fees, and court costs.
Okay.
There's also an allegation about failing to complete mental health treatment, but he is enrolled and going.
Well, excuse me. Let me talk for you, or you can not be represented by him. Let me ask some questions. The state's not making an offer, but it sounds like it's technical type things. But given that the state's not making an offer, it seems like denial is the only sensible option. But apparently, Mr. Alberti, may I listen to him and
Sure.
he has some.
What? I'm sorry. Let me pull it up. I looked at it last night. There is a VOP affidavit, but the request was for an order to appear, not a warrant. That's why he's here on an order to appear, and he's not in custody on a no bond warrant.
And, well.
And it's
it sounds like this is
essentially
just
financial.
Just financial stuff. Is this the kind of thing that the state would consider allowing to just, you want it to go to collections, or do you have a driver's license?
Yeah, I don't want to negotiate on the record right now, so we could talk about it. I'm working with Mr. Profit right now to see if there was any restitution, and if so, if that's been paid on the 24 CF 1711 case.
But, Your Honor, it's an order to appear for violation of probation or community control. If
Right.
it's appropriate, we can enter a denial today, or we can
Yeah.
just simply continue everything. It sounds
Well-
like maybe it's not needed. But,
So the order to appear is in lieu of a warrant.
okay, then we will enter a denial.
Okay.
But he was, no disrespect, but he was resistant to me entering a denial, so hence my confusion, so.
Okay.
Apologize, Judge, but
No problem.
state's willing to revoke and terminate. My concern that I had with him is he does have a driver's license. I don't want monetary obligations to go against his driver's license.
Yeah.
Therefore, if it would be possible, I would like to have a revoke and terminate so that he's no longer under supervision, which seems to be acceptable to the state and state probation. But yet, if the court could give him 12 months before outstanding monetary obligations go to collections, then he could get that stuff paid. I apologize for doing this on the record.
So the report from the probation officer was positive. This is also the reason I mean, it's mostly financial. That's why he's here on an order to appear.
I got you. Thank you, Your Honor.
But it's a positive report and
Yes,
recommendation from the probation officer. The recommendation was revocation of supervision and all monetary obligations set to a civil lien. He completed his substance abuse treatment, has not had any positive UAs. He's always home when he's supposed to be. The officer requested a waiver of all cost of supervision, including arrears. And this is Officer Keene. The other alternative, well, first of all, it says the officer is requesting that if he's completed his mental health evaluation and is enrolled, I was thinking he was enrolled, that extend community control for another 8 months to let him complete that. And then he could auto-terminate.
He represents that he's done with mental health evaluation treatment. Is that? All right.
Hey, Steve.
That would be great. Yes. Your Honor, the state, if the state will just announce.
Remember, the state's going to dismiss the VOP. I just spoke with Officer Profit. He has completed his mental health evaluation. He's completed all his technical requirements. This does look financial related. The state would also ask the court, if possible, to allow him any, it looks like just court cost is what he owes, but allow for any community service work that can be applied to court costs, to allow that to be applied, to at least give him an option to maybe do some community service in lieu of payment.
And if we could have some time to look into that and pursue that, could we have 12 months before the unpaid obligations go to collections?
Let me check with Madam Clerk. Do you need an order for him to be able to do the community service for eligible costs?
No, it's announced on the record. I don't know if it's on the record.
So there are actually 4 allegations. One is cost of supervision, arrearages, and the recommendation was to waive that. That's from Officer Keene. Officer Profit, the court is granting or abiding by probation's request or recommendation to waive the cost of supervision arrearages. So, sir, that takes care of one allegation and saves you some money. Then, let's see, there's also an allegation, actually there's 5 allegations. Number 5 is failing to pay for drug test fees. And does probation have a position on that as well?
We will close
Okay.
as is.
Okay. So that takes care of that allegation.
Yes.
Then court costs. It looks like there is restitution. The arrears on the restitution The amount is $747.76. That's as of August 12th. I'm reading from the VOP paperwork. And then court costs, the amount is $668.82 was the arrearage as of August 12th. So those two are still outstanding. Then there's this issue about mental health evaluation and treatment. So Madam Clerk says that as long as I announce it on the record, he can, I don't mean to talk about you like you're not here, sir. Sir, as long as I announce it on the record, you would be able to do community service work for whatever court costs you're eligible for that. There are certain costs that are eligible for you to work off through community service and some that aren't. So you'd have to get with the clerk to see which ones you could work off through community service.
Yes, ma'am.
I'll go ahead and make that announcement that whatever court costs are eligible to be worked off through community service, he may do so. He just needs to get with the clerk. And then, what about the restitution?
I would suggest, Your Honor, that unpaid monetary obligations.
Your Honor, I don't see any restitution in this case.
Huh, okay.
Well, thank you.
Maybe is it in the other, I mean, there are two cases. We've got 24 CF 1711. That might be the case with the restitution.
It may have been something transferred from an older case, but I don't have any knowledge, Your Honor. Sorry.
Let me pull up that case. I was looking at the other one. And I see receipts for payments that Mr. Alberti has been making to the clerk. I mean, just, small payments. I believe those would be towards his court costs.
Yes, ma'am, we do not apply any restitution payments on our probation.
So he's been making an effort to pay those. And
He doesn't think he has any restitution, Judge.
okay.
Your Honor, may I ask a question of probation?
Sure, go
Does
ahead.
probation have any idea why it shows as restitution on a VOP report if there's not really restitution?
I'm not sure. What case is it?
24 CF 1711.
Yes, I'm not showing any restitution. It may be an error.
I'm looking at the probation order that was entered in September of 2024. I don't see restitution in there.
He did have two cases in 2024, I think.
Yes, the probation order covers two cases, 24 CF 1305 and 24 CF 1711. Let me look at that VOP affidavit again. Okay. So I'm looking at the VOP. It's the violation report. It was filed on August 13th, 2025. Thank you so much. And allegation number 3 says, and it gives a case number of the 1305 case, but it says failure to pay restitution, court costs, fines, and costs. But then it says violation of condition number 10 of the order of probation by failing to make restitution payments as directed. And that the offender was $747.76 in arrears. I suspect that's costs, not restitution, because the previous allegation, it's allegation number 2, is the other case number, and it's about costs, and it has a dollar amount. And I didn't see any restitution ordered in the probation.
And that language seemed to be multifaceted, restitution costs and fees
Yes.
kind of a thing.
Well, but
But-
that allegation, it specifically says restitution, but I think that's an error. I think it should say costs.
I apologize, Judge, I'd be happy to research it, but we could cover his bases by just having unpaid monetary obligations not go to collections for a period of time acceptable to the court. And then if there is anything restitution-wise, he could get it paid, but it sounds like there probably isn't. But he still has to deal with the cost issue, which he doesn't want to go against his driver's license, and some of which he can probably do with community service if he's able to do that. It sounds like a good approach, Your Honor, respect.
Okay, so I think that's,
Just court costs.
it's just court costs, so that's a typo in the VOP affidavit where it says restitution, that should be costs.
Thank you, Your Honor.
Sure. So, state has dismissed the VOP in both cases, correct?
That's correct, Your Honor.
Okay, and then I've announced that Mr. Alberti can, if you wish, sir, you can do community service work for whatever court costs are eligible under the Florida statutes for that. That'll help you if you want to go that way. Then the remaining court costs, then 90 days, is that agreeable to the state?
Yeah, I would ask for more time,
Okay.
just because of his, the hurdles, the various challenges that he has.
Okay,
I was maybe being greedy, I was asking for 12 months, but could we at least get 6 months, Your Honor?
That's fine for the
Okay.
state, Your Honor.
all right, I'll give you 6 months. And any of your court costs in either case that are not paid off or worked off in 6 months, those will go to collections, okay?
And you can get on a schedule too, and that may help.
If you'll go see the clerk, they'll work with you.
Go.
So just put on.
Go. Thank you, Your Honor.
Sure, thank you. So that would terminate Mr. Alberti's probation, correct, Officer Prophet? He's terminated then? That's correct. All right. Thank you, sir.
And the PD wasn't assigned, so there's no PD fee.
Okay.
A friend of the court.
Yeah, the state announced a dismissal. Thank you. Mr. Catalinic, are you ready?
Yes, Your Honor, I am. Thank you.
All right. This is case 22, CF 1093, Jarrett Kearney.
Yes, Your Honor, he's before the court. Your Honor, may I approach? I have a plea.
Yes, absolutely. Thank you.
Your Honor, this also takes care of this 25 MN 2656 misdemeanor VOP.
Wonderful.
Misdemeanor case.
Okay. Is there previously an adjudication of guilt on these underlying charges?
Yes, Your Honor, on the bat Leo?
Yes. Thank you.
So essentially, Your Honor, he's admitting to the VOP and pleading no contest to the MM.
And it will be a reinstate and modify?
Yes, Your
For the
Honor.
VOP?
6 months of community control, followed by the completion of his original probation and all the terms under it. No trespassing, and I think it's stated in there where he can't trespass the address as well. $100 VOP fee, and he'd be adjudicated guilty on the misdemeanor with court costs.
So will the termination date remain the same?
Yes, Your Honor.
Okay. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down if you'll state your name, please.
Jarrett Kearney.
Thank you. You're here on allegations that you violated your probation in case 22 CF 1093, and you're also here on a new law offense in 25 MM 2656 of disorderly conduct, which is a misdemeanor. Have you had a chance to talk to your lawyer about the allegations that you violated your probation in the felony case and also the charge in the misdemeanor case?
I have.
Have you discussed the plea agreement with your lawyer?
I have.
I think he needs to sign it.
I'm sorry.
Oh, no problem.
I apologize.
No problem, right there.
Right here, Mr. Kearney.
Matt Brush.
Yes. Thank you very much. Thank you. All right, sir, is this your signature on the back page of the agreement?
Yes, Your Honor.
All right. Do you understand that you're giving up your right to have a contested hearing in the violation of probation case, and you're also giving up your right to have a trial in the new misdemeanor case? Okay, I need you to answer out loud.
Yes.
Thank you. We have a court reporter listening, and I want to make sure she can hear and make a good record, okay? Are you entering the admission to the allegations that you violated your probation freely today?
Yes, Your Honor.
And are you entering the plea on the new misdemeanor case freely today?
Yes, Your Honor.
Is anyone forcing you or threatening you?
No.
Are you satisfied with the services of your lawyer?
Yes.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No.
I do have a score sheet. It shows 28.9 total sentence points. Any objections or corrections?
No objection.
On the new law case, is there any exculpatory DNA?
Not that we're aware of, Your Honor.
Okay. And is there a stipulation regarding a factual basis?
We stipulate.
Mr. Kearney, if you're not a U.S. citizen, do you understand the plea could subject you to deportation?
Yes, Your Honor.
Are you admitting the allegations that you violated your probation in 22 CF 1093?
Yes, Your Honor.
I accept your admission. I find it was freely and voluntarily given. And how do you plead in 25 MM 2656 to one count of disorderly conduct?
No contest.
I accept your plea. I find it was freely and voluntarily entered. In accordance with your agreement, in your felony VOP case, probation will be reinstated and modified. The next 6 months will be on community control, followed by the remainder on standard probation under the same terms, and or you'll still have to complete all your same terms and conditions if you haven't already done so. And then, if these are not already terms and conditions, these are imposed. No trespassing at 212 Miracle Strip Parkway, Fort Walton Beach, which is the downtown music hall. You must attend and complete an anger management course at Pattison Professional Services, I believe is the name of that facility. And then there's a $100 VOP cost of prosecution fee. And did I cover all the terms and conditions on the VOP case?
I believe you did, Your Honor.
Okay, let me check with that. Did I cover everything? Okay. Then on the misdemeanor case, 25 MM 2656, in accordance with your agreement, you'll be adjudicated guilty of that charge, and you are assessed $270 in court costs. Let me make sure that's right. Yes, okay. And I guess it's just time served on that charge then? Or
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. And so, sir, is this the only thing holding you in jail?
Yes, Your Honor.
Okay. Assuming you don't have a hold somewhere else, then you should get out, hopefully today. You have 30 days to appeal the orders of the court in both cases. If you can't afford a lawyer, I'll appoint one for you. As soon as you get out, well, Officer Prophet, does he need to see you before he leaves the courtroom?
Yes, he'll see me.
Okay.
And he needs to report directly to Officer King.
Okay, does he need to do that probably in the morning? I don't know if he'll get out in time today. Okay, so in the morning, you need to go report to Officer Keene, but see Officer Prophet before you leave this courtroom today, okay? Good luck to you, sir. Thank you. Oh, how much time to pay for the misdemeanor cost?
Your Honor, if we could have 90 days?
Yes, 90 days. All right. I'll write that down as well. Thank you.
Your Honor, I have one more case if I can.
Yes.
Mr. Chandler Allen, A-L-L-E-N. And Your Honor, 23 CF 2676. Your Honor, I did a change of plea on this case as well, like the last case. But we haven't gotten into an agreement with the state, Your Honor. So what we're going to ask for is another court date. I'm going to have to do that with your office.
Okay, and I don't see him on the, yes, I do. He is an inmate, so maybe we should bring him out.
Yes, Your Honor.
Okay.
Chandler Allen.
Mr. Kedlenick, what's that case number again?
I'll show you. 23 CF 2676.
He is number 34 on the docket. He's listed under Mr. Medina's case list, but I saw Mr. Catalinic had, I believe, filed a notice of appearance.
Yes, Your Honor, I filed it on the 13th of October.
Yes.
Your Honor, I don't know where we are on filing our order to relieve the public defender, but we will follow through, Your Honor.
Yes.
Thank you.
Thank you. So Mr. Allen will be out momentarily, and we'll fill him in on what's going on. Looks like there was an affidavit filed on September 16th. It included 3 allegations, plus one of those is a new law.
Correct, Your Honor. That's 25 CT 1713.
That's right. So he should be out momentarily. All right. And I believe this is, are you Mr. Allen?
Yes, ma'am.
All right, I'm Judge Clark, and you're here on 23 CF 2676 on allegations that you violated your probation, and you need another court date, Mr.?
Your Honor, we're going to ask for another court date. I don't know when the next court date actually is on this case, but we haven't gotten into an agreement with the state yet.
That would be November 18th.
November 18th, Your Honor, and if something happens, I'm going to ask for an earlier court date.
And if I can, in any way possible, accommodate you, I will.
Yes.
Yes, absolutely. I will make every effort to get you in earlier if you need to be.
Thank you, Your Honor. That's all I have.
Thank you.
I
November
appreciate it.
18th at 9. Thank you.
Thank you, Your Honor.
Your Honor, could I slip in with one out of custody that Ms. Bosco had?
Sure.
Mr. Dondre Blackman. We have an agreement to resolve the DOP tying into a new law that he pled out on July 24th, 2025. So in essence, he's going to be able to do some concurrent community control followed by the balance of his probation. May I approach with the fully signed agreement, Your Honor?
Yes.
And it's reinstated and modified, so there's not a score sheet, Your
Thank you,
Honor.
thank you. All right, and there, I have down that there are 2 case numbers. I only see one.
Yes, ma'am, just for the record, it's going to be 15-2266, I believe, and 24-2296.
Okay, so.
I need to add that one then.
Yes.
It does look like there is, most should have been on there, I apologize.
No problem. So it's 24 CF 296 needs to be on there as well.
I missed that as well, Mr. Medina. I'm
No
sorry.
worries, my bad.
So do you want me to give you a minute, or will you be able to?
I'm sorry, Your Honor?
Do you want me to give you a minute and recall the case?
Oh, no, Judge, I'm
Okay.
just putting the number on there. He was fully aware.
Okay.
He's aware of the VOP and of the agreement. You see that one change? We just needed to add that other case. And I see it on the paperwork, I just, may I approach, Judge?
Yes.
Doesn't change the terms.
Thank you, thank you. I am having to write something on the costs. You may want to show, well, you may want to show this to Mr. Blackman. I had to write on here to clarify the costs per
Yes,
case,
sir.
so maybe get him to an...
there's two.
Yeah, if you'll get him to an...
Instead of one,
Yes.
Judge, I'm sorry.
That's okay. And those are mandatory costs I'm required to impose, so.
Yes, there's the court added, so the cost of prosecution, $100 per case, and then there's PD fee for extra 100 for the other case. All right, sorry.
Sure. Thank you. All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. If you'll just state your name, please.
Dondre Jamar Blackman.
All right, thank you, sir. In 15 CF 2266 and in 24 CF 296, it's alleged that you violated your probation. Have you had a chance to review the allegations that you violated your probation in both of those cases?
Yes, ma'am.
Have you discussed the plea agreement with your lawyer?
Yes, ma'am.
Do you understand that you're giving up your right to have a contested hearing and make the state prove those allegations?
Yes, ma'am.
Are you entering the admission freely and voluntarily today?
Yes.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No.
All right, sir. Are you admitting all of the allegations in the affidavit that you violated your probation in both cases?
Yes.
I accept your admission. I find it was freely and voluntarily given. In each case, probation will be reinstated and modified, and you will be placed on community control for the next 9 months, followed by the remainder of your supervision on regular probation. You'll have to complete the original requirements, whatever you haven't already done. Yes.
Just for the court's awareness, unless, in case I didn't spell this out specifically, but on July 24th, he took a 1-year CC in the 25 CF case. So this is going to also run concurrent with that case as well for the
Yes,
community control. I think it stands to reason, but I just wanted to.
Yes, all of these cases will run concurrently. So there, and I had a note about a new law. A plea was entered on July 24th in 25 CF 1252. So both of these violation of probation cases will be concurrent with that at the same time. So
They may not have exactly precisely the same day of finishing the 1 year and the versus the 9 months. We made it as close as we could.
So there may be different termination dates on each
That's,
case, but
that's
for
just
your-
for the CC part of it.
Yes.
He still has to do a balance of probation.
Correct.
On the remainder
Right, so.
with regular probation.
Speak with your probation officer about when your community control terminates in the, in each case, because they may not all terminate on the same day on the community control, okay? All right, so you'll have to complete all of your original requirements, whatever you didn't already do, and then I do need to impose mandatory costs. So there's a $100 cost of prosecution fee per case, so that's two $100 cost of prosecution fees. This is in addition to any previously assessed court costs in these cases. And then in 15 CF 2266, there's a $150, well, let me check. You may have already covered the application fee in that 2025 case.
I don't think the VOP had been issued, so probably not. He probably had to reapply.
Okay. And Officer Profit is, yes.
The subject is a past term and a number of counts it indicates. So we either need to relook at how much time we can extend on the counts.
Okay. So.
That's something he'll have to sit down. I can't, I mean, it looks like the LNL that he originally pled out with in 2014.
Past term.
It's a 15-year max, so it can be reinstated and modified to add time, Judge, basically that one can go to, it looks like approximately 2029. But is the intent of the state that if he finishes his community control, that he doesn't need to be supervised anymore?
If there was any supervision or any probation remaining, that he would continue, that he would serve any remaining probation that was originally ordered on the outstanding
But it
cases.
sounds
That was
like-
the intent.
It sounds like there wouldn't be any, is that right, Officer Prophet? Yeah, I'm sorry, Judge, I didn't realize this complication.
I just looked and Mr. Blackman was assessed the $50 application fee in his new law case. So I'm not
Okay.
going to charge him another one in
Thank
the
you, Your
VOP case. So actually, the cost of defense in each of these VOP cases is $100, not $150 in one of them.
Thank you, Your Honor.
Sure, he's already paid that application fee. And the VOPs, I think, were pending at the time he pled on the 2025 case, because at that time, there was a stipulation for an ROR bond on the VOPs once he pled on the new law, which is why he's.
Right, I think we probably had a discussion that he would come back and we would
Yes.
give him concurrent treatment, so that's
Yes.
in essence what he's getting.
Absolutely. So
That's
let me
correct.
Look at the, I'm looking at the 2015 case right now.
It looks like that was a third-degree felony with a 5-year that was pled out in 2024. So both of them could have more regular supervision, but I think possibly the state had not required more supervision, so maybe there's no probation to follow the CC.
So we'll address the count one, case number 15, CF 2266. We address that. We need to address the past term in count two, case 24, CF 296.
Judge, I don't have the original, all I have is the affidavit of violation, and it just says one charge, one offense. Originally sentenced on, so basically there may be, in other words, what I'm suggesting, is it possible, may I address the probation directly, that these other counts just simply terminated, they're not showing up on the VOP affidavit, so we really don't need to address them?
No, that's not correct.
Okay.
Because I usually go based on what's on the affidavit of violation. If there were old, like a misdemeanor from 10 years ago, I usually don't have to cover that in the VOP paperwork. I don't write down all the charges if only one of them was still
It looks
pending.
like in 24 CF 296, there was one count of failing to report, and there was a plea agreement on that case it was February 20th, 2024, and it says 18 months community control in that case. The 2015 case, 2015 CF 2266, at that time, there was a VOP on that. And there was a reinstate and modify the remainder of that probation to community control at that time. So, and then it was concurrent 18 months community control in the 2024 case. Now, this took place back in February of 2024. Then, let me see what happened after that. There was an order of community control entered March 28th, 2024. It was following that plea. And that states that Mr. Blackman was adjudicated guilty of that one offense. It was count one. Placed on community control for a period of 18 months concurrent to the 2015 case. So then let me see what happened after that. Then there was an affidavit, a VOP affidavit filed on June 25th, 2025. And there were some new law, some allegations of a new law offense, which I suspect is that 2025 case that was pled out in July.
Yes, Your Honor.
Yes. And then there were some allegations that were specific to the 2015 case. And then the only allegations that I can see specific to the 2024 CF 296, other than the new law allegations, were court costs.
Right.
So, and failing to pay for monitoring and things like that. But it looks like Mr. Blackman, there was only one charge in the 2024 case. It was just a third-degree felony. And the original sentence in that case was 18 months community control, but then there was this violation.
And Your Honor, I don't know why,
There's no
but basically,
probation.
this old 2015 case, I don't have the original file. I have a duplicate file, so I don't even know what the original plea agreement said as far as what charges were dealt with, because the only thing I see on the 2015 case is a reference to an L&L battery.
Okay, I'm looking at the original plea agreement in 2015 CF 2266. There were 3 counts. Count 1 was a second-degree felony, and counts 2 and 3 were third-degree felonies. There was an adjudication of guilt on all 3 charges, and it says in all 3 counts there was a DOC sentence, and probation was only ordered in count 1.
Yeah, so I think basically
Following, yeah.
there's no probation or other supervision as to counts 2 and 3, so I don't
Correct.
think we need to deal with it.
It's only the count 1 in 2015 CF 2266. It was the DOC sentence followed by 5 years of probation. And that included the GPS monitoring and all the counseling and all the other terms and conditions. And it was no probation was ordered on counts 2 and 3 in 2015 CF 2266. So
It does one point, may I, Judge?
sure.
there is, basically today, there is a reinstate and modify. And to make it all clear, the state is allowing him, subject to the court approval, basically everything is gonna be handled with the community control, it sounds like to me, because there is no regular probation to follow, because basically it had previously all been community control, it sounds like. Subsequent to the original sentence was DOC followed by probation. It has since, including in 2024, been modified to community control. There was originally some probation too, but that's all been superseded.
Yes.
And now we're superseding it yet again to make it all very clear. It's 9 months in these two cases.
So I'm looking at it, on the plea agreement, it says 9 months community control concurrent, followed by remainder supervision on regular probation.
I wrote that because, no disrespect, but that's what the state said, but I did not independently research it, I apologize, but it sounds like from what everybody's saying, there is no probation separate from the community control.
And ma'am, in going through that, as the court was going through it, I did verify it does not appear there is any probation outstanding, so we believe with the 9 months that should then take care of it.
So I should probably line that through, excise that from the agreement. Sorry,
Yes,
Judge.
no problem, and I'll go back and pronounce the sentence again. So I'm just gonna,
And I apologize for not
no problem,
checking that out before today.
no problem. Well, it was confusing with all the different cases.
Well, we were in court all day yesterday, and less than quality work sometimes.
Okay, so sir, I already accepted your admission in both cases on the violation of probation. Here is the sentence. So this modifies or supersedes anything I'd said previously, okay? In both of these violation of community control or probation cases, 15 CF 2266 and 24 CF 296. You've admitted to the violations that were alleged. Your community control is reinstated and modified to 9 months, starting now, of community control. That will run concurrently with your case that you pled out to in July, which is 25 CF 21252. So all three cases will run concurrently, but they may not end at exactly the same time. Talk to your officer about that. There's no probation to follow. So once you complete your community control, now I didn't check the 2025 case. I don't remember if there's probation to follow in that case.
There's not, ma'am. We've gone through, we had to modify that to the community control previously.
So in these two cases you're here on today, the 2015 case and the 2024 case, once you finish your 9 months of community control, you're done on those cases. You're not on probation to follow after the 9 months.
And Your Honor, I confirm, I'm looking at a copy of the felony minute sheet in 25 CF 1252 that did very clearly say it was 1 year CC. It doesn't say anything about any separate probation. I do want to note on the record for his consideration, especially with respect to monetary obligations, that he really needs to make sure he's doing everything possible to pay those off before the 9 months runs out, because you don't want that stuff going against your driver's license.
Okay, so it's in each of these VOP cases, the modification is 9 months of community control, period, no probation to follow. Then I do have to impose the fees. I'm going to restate those fees because I went and looked and saw that you already paid the $50, or you were already assessed the $50 application fee in your 2025 case. So I've removed it from one of these cases. In each of these VOP cases, there's a $100 cost of prosecution fee, that's mandatory. And then there's also a $100 cost of defense fee. Again, it's not 150 on one of them, it's 100 per case. Cost of prosecution, 100 per case, cost of defense. That's in addition to any previously imposed cost or fees. Did I cover everything? And let me check with Officer Profit.
The treatment, I guess that.
Any unfinished requirements?
He has to complete his
He needs to
existing
complete those.
obligation.
Original condition.
Yes, sir.
Yes.
Complete all the original terms and conditions. He also has to, that includes a monitor that he's wearing.
Yes. So all of the previously imposed conditions are still in effect. They're reimposed, you still have to complete them and comply with them. So that'll include the monitoring and, okay. Sir, you have 30 days to appeal the order of the court, and if you cannot afford a lawyer, I'll appoint one for you. Good luck to you, sir, and does he need to see you before? Okay, go see Officer Profit, and then you'll need to check in later today.
Thank you, Your Honor.
Thank
Judge
you.
Clark, ma'am, I'm doing a meeting at the state attorney's office. May I leave?
Yes.
Thank you.
Yes. Thank you. All right, Mr. Garrett.
Good morning, Your Honor.
Good morning.
Ms. Copeland? Chris Garrett on behalf of Catherine Copeland, 24 CF 884. She is approaching.
Okay.
And Your Honor, we are going to enter a change of plea today and enter a plea of no contest. Just go through it broadly. The sentence is going to be concurrent between counts 1 and 2. Count 3 is going to be dismissed. Count 1 is going to be amended to a lesser included offense of sell, manufacture, deliver fentanyl. Count 2 will be amended to adjudication of guilt, lesser included offense of sell, manufacture, deliver methamphetamine. Overall, Your Honor, the sentence is concurrent between counts 1 and 2, 5 years of probation, a substance abuse evaluation, and any recommended treatment, attend 2 Narcotics Anonymous meetings per week and provide proof to probation, maintain gainful employment or submit 3 applications per week, 50 hours of community service work. There's no objection from the state to transferring her supervision to Bay County, where she currently resides, $615 in court costs, and defendant may be issued a hardship license for business purposes only.
Well, let me back up on that one.
Yes, Your Honor.
I cannot order the Department of Highway Safety and Motor Vehicles to issue a hardship license. That's between you and the Department of Highway Safety and Motor Vehicles. If you qualify, you'll have to contact them. They'll probably set a telephone hearing with you and a hearing officer with their agency, but I have no control over that process. All I can say is I don't object to you getting one if you qualify, but I cannot order them to give you one.
Yes, Your Honor. Understand.
Sure.
If I may approach with the plea and sentencing?
Yes, yes. Thank you. Thank you so much. I'm going to write on here where it says defendant may be issued a hardship license for business or employment purposes only if otherwise qualified.
Yes, Your Honor.
That's up to Department of Highway Safety and Motor Vehicles. So I wrote, if qualified, as determined by Department of Highway Safety and Motor Vehicles. Again, that's something you'll have to contact that agency and do whatever requirements there are to get that hearing, and then they'll see if you qualify, okay? Are the court costs $615? Okay, thank you. All right, ma'am, if you'll raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth? If so, say I do.
I do.
Thank you, ma'am. Could you state your name, please?
Catherine Copeland.
All right, you're here in 24 CF 884. And in that case, you're charged with 1 count of trafficking in fentanyl, 4 grams or more, but less than 14 grams. That is a first-degree felony. It carries a maximum of 30 years Department of Corrections and a minimum mandatory sentence of 7 years State Prison, Department of Corrections. Also, a minimum mandatory fine of $50,000. Count 2 is trafficking in amphetamine or methamphetamine, 28 grams or more, but less than 200 grams. That is also a first-degree felony. And the maximum penalty would be 30 years state prison. There's a mandatory fine of $100,000 and a minimum mandatory prison sentence of 7 years. Count 3 is possession of a controlled substance less than 20 grams of cannabis. That's a first-degree misdemeanor, and that carries up to a year in jail as the maximum penalty. Have you had a chance to talk to your lawyer about those original charges and any possible defenses?
Yes, ma'am.
All right. Have you discussed the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the next to the last page?
Yes, ma'am.
Do you understand the rights that you give up when you enter a plea?
Yes, ma'am.
Do you understand you're giving up your right to go to trial on these charges?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing on this agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
Did he answer all of your questions?
Yes, ma'am.
Have you had any drugs, alcohol, medicine, or any substance in the last 24 hours?
No, ma'am.
I do have a score sheet here. It shows 39.8 total sentence points. Any corrections?
No, Your Honor.
All right. Ma'am, did you look at the score sheet?
Yes, ma'am.
Did you see any errors or any problems with it?
No, ma'am.
Okay. The reason I ask is you're very close to scoring prison. You're going to be on probation in accordance with this agreement for 5 years. If you have a violation, you're probably going to score prison. I just need you to be aware of that. I want to make sure that you didn't see any problems or errors in the score sheet.
Yes, ma'am.
Okay. Is there any exculpatory DNA?
No, Your Honor.
Okay. I do find a sufficient factual basis based on my review of the arrest report. Ma'am, do you understand that if you're not a U.S. citizen, the plea could subject you to deportation?
Yes, ma'am.
Do you understand that an adjudication of guilt on these charges will likely result in your driver's license being suspended?
Yes, ma'am.
All right. Do you understand that the court, as much as I would like to order defendants to have a business purposes only license in every case where they get their license suspended, as much as I would like to do that, I do not have the ability to order the Department of Highway Safety and Motor Vehicles to give you a business purposes
Yes,
license. Okay. I just want to make sure. They don't tell me what to do, and I can't tell them what to do. So
Yes,
there's a statute that sets forth the requirements, and you'll have to contact them.
Yes, ma'am.
All right. Looks like you're pleading to a couple of lesser included offenses, and those are, as to count 1, lesser included offense of sale, manufacture, or deliver a controlled substance, fentanyl, and the statute is 893.131A1. Then, as to count 2, it looks like you're going to plead to the lesser included offense of sell, manufacture, deliver methamphetamine. And the statute is the same, 893.131A1. And how do you plead to those lesser included offenses on count 1 and 2?
No contest.
I accept your plea. I find it was freely and voluntarily entered. Does the state have an announcement on count 3?
And the state will be null tossing count 3 in exchange for a plea to the other counts.
All right. In accordance with your agreement, ma'am, on count 1 and count 2, those lesser included offenses, you are adjudicated guilty of each of them. And on each count, you're placed on 5 years of probation concurrent. And there are some special terms and conditions. Those are, you'll have to complete a substance abuse evaluation and any recommended treatment. Is there a time frame to complete that evaluation?
Within 30 days, the appointment needs to be scheduled, and any treatment within 60 days.
Okay. I'll write that on here. Okay, so you will have to have that evaluation within 30 days. That'll be scheduled with probation, so when they tell you to go, you need to go, okay? And then if they recommend any treatment for you, you need to start that treatment within 60 days, okay? Then you must attend 2 NA meetings per week, and you have to provide proof to probation that you went. You'll have to maintain gainful employment or submit 3 job applications each week. You'll have to do 50 hours of community service. I would recommend that you don't wait till the very end to try to do that. It's going to be too much to do. Start working on that right away so that you can get it done, at a reasonable time and not have to do a ton of it at the very end of probation. There's no objection to transferring your supervision to Bay County, but you need to check in here and get that arranged first, okay?
Yes, ma'am.
$615 in court costs, and the court has no objection to you getting a business purposes only license as long as you're qualified to do so. Did I cover everything?
I believe so, Your Honor.
Okay. Ma'am, you have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you. See Officer Prophet, he's sitting on the front row right there. See him before you leave the courtroom. Then you'll have to go check in here to probation today as soon as you leave court, okay? Good luck.
Thank you, Your Honor. I believe that's all I have.
Thank you, Mr. Garrett.
Have a good day, Your Honor.
You too. Do I have Amber Godbolt present? Come on up, ma'am. This is case 24 CF 1628. Yes, ma'am, if you'll just state your name, please. If you'll just tell me your name, please.
Amber Godbolt.
Thank you, ma'am. I'm Judge Clark, and you're here on an order to appear for violation of probation allegations, and I see that you don't have a lawyer. Would you like me to appoint one?
Yes, you can appoint me.
All right, I'm appointing the Office of the Public Defender.
Is there a penalty for the double consider?
It's 30 days OCJ.
Just verify something.
Sure.
You said 30 days of what? I've completed the probation.
Hold on just 1 second, ma'am.
Your Honor, Officer Prophet just confirmed that she's completed her probation, so the state will be dismissing the violation.
All right. Well, then I'm not, I'm unappointing the Public Defender's Office, and the state has dismissed the VOP, so it sounds like your probation has already been terminated. But let me verify with Officer Prophet. Has her probation already expired, or does she need to stay on until she terminates?
No, she terms today.
Congratulations, ma'am, you are done with probation. Thank you. Do I have Robert Harris present? And that is 24 CF 1655. Yes, sir. Are you Mr. Robert Harris?
Yes, ma'am.
Thank you. I'm Judge Clark. You're here on allegations that you violated your probation, and You don't have a lawyer appointed yet. Would you like me to appoint one?
Yeah, I guess. Yes, ma'am.
Okay, I'm appointing the Office of the Public Defender.
Is there an offer for Mr. Harris to consider?
So it looks like the outstanding conditions are fees and to complete community service work. The state would be fine to continue it to allow that to be done for the next court date.
Could I pay out the fees now? I was on waiting for the court date, meaning for the, buy the community service stuff.
Okay.
But I was getting new probation's office, so I couldn't do it.
All right.
My suggestion, we are unappoint the PD, continue in our denial, continue it for a month. If he provides proof that it's completed, then he can terminate.
All right, does that sound good?
Yeah.
Sir? All right, what I'm going to do is I'm unappointing Mr. Gates. That'll save you a little bit of money.
All right.
We can always appoint Mr. Gates at any time if you need him, okay? I'm going to reset and continue your case.
All right.
So for purposes of today, are you entering a denial to the allegations?
Yeah.
Okay. And let's reset your case for November the 18th at 9 o'clock. There should be some notices up there that you can write that court date down on.
9 o'clock. So I can pay it off, right?
Yes.
Like I can pay it off today.
Well, do you want to go do that and then come back in the courtroom and see where we are?
Well, I'm Ubering, so.
You're what?
Ubering.
Oh, you mean you Ubered to get here, or you're an Uber driver?
I'm Ubering.
Okay,
I
you
Uber
can-
to get here, so why I gotta go pay the, what's the name at? It's online, right?
Let me check with Officer Profit, or if you can go down to the clerk's office and take care of it.
Yeah, I asked the clerk office this morning. She said I had to do it somewhere like online. I paid the court fee today, though.
Let's see what. And then there's community service.
Conversation going on, Your Honor, at this point, even if it was to pay it, it won't reflect in the system of JCS, or not state probation. So the preference would be just to continue it. Once he pays that, they'll verify it, and then we'll just terminate probation, because he's already passed term anyway.
Okay.
He technically won't need to come back to court once that's been terminated.
Okay, so, and will that apply to the community service as well?
Yes.
Okay. So you'll have to pay your outstanding costs. There are 3 allegations in that, what was attached to your notice to appear, I attached it. 3 allegations. It was court costs, cost of supervision, and community service. So once you pay all of that off, I'm going to continue your case to November 18th. There should be some notices up there where you can write that court date down.
November the 18th?
November 18th at 9 o'clock.
All right.
And if you get everything paid off and taken care of before then, check with your probation officer, and then if probation could let the state know, or, oh, looks like you paid something today.
Yeah, that's what I'm saying. The only thing I gotta pay is the supervision, whatever that is. I paid the court cost today, and I already did the, whatever, the substance, whatever, class. So the only thing I got left now is just to pay the probation officer.
Officer Profit notified me that even if the payments are done today, it's going to still have to process through their system. So we're not going to be able to do that today. So once everything is processed, we can go ahead and terminate it.
Okay, so will Mr. Harris be notified that he's good to go and doesn't have to come back to court?
He needs to stay in contact with his current probation officer.
Okay.
Once you get everything paid, advise that officer, and the officer will update the court.
All right.
Okay, so your court date could be canceled, but right now, we're setting you for November 18th at 9. But if your probation officer says that you're done with everything prior to that date, then you would not need to, they need to advise the state.
All right.
All right, and then you'd be terminated.
All right.
All right, thank you, sir.
Yes, ma'am.
All right. Is Cedric Hill present? Cedric Hill, that's 23 CF 600. All right, I will recall Mr. Hill in a little bit. All right, Mr. Harper?
Yes, Judge, I have two in custody.
All right.
Doesn't matter.
Yes.
Judge, this is Clint Jones. He's before the
Yes.
court on 24 CF 972 and 24 CF 973. The
Yes.
court may be aware that Dr. McDonald did complete her report and has filed it. Both the
Yes.
state and I have received it. She came to a determination of incompetency, and the state is stipulating to that finding.
That is correct, Your Honor.
Okay. Are the attorneys stipulating I can rely on the report rather than live testimony?
Yes, Your Honor.
Yes, Your Honor.
Okay. So Mr. Jones is present. We're here in 24 CF 972 and 973. I did review the report from Dr. McDonald filed on October 19th, 2025, and she was of the opinion that Mr. Jones is not competent to proceed at this time and that he is restorable, and she recommended the hospitalization and that Mr. Jones meets criteria for that. So the court is going to make a finding of incompetency to proceed and that Mr. Jones does meet criteria for inpatient restoration through Department of Children and Families. So what we need to do is set a control date, maybe in about 3 to 6 months. So let me get one of those, get a date for you. I only have my court dates here through the end of the maybe January or February. Maybe let's go with January, just in case.
Once you're stabilized, I'll bring you back, okay? I declare conflict. I need an answer.
So you have January 13th at 9.
All right, thank you. January 13th at 9 o'clock will be a control date on status of restoration.
January what date?
13th at 9 o'clock. All right, and will the state be sending an order?
Judge,
Who's
if
gonna
not
send-
now, I can send an order.
Okay, I don't know who's going to send an order.
My
but-
assistant is out today, but I'll have that filed in the morning.
Okay.
So, while I go do this, while I go to the hospital and get stabilized, why don't you look at the evidence that we can drop the charges?
Thank you, Mr. Jones. Thank you, sir.
Good day, Judge.
You too,
Clark.
thank
I will
you.
see you back at
January.
January 13th will be the next court date.
That is a status date to see how you're doing. So I'm not sure if you'll be with us on that day or not, but I'm going to be asking for a status on how you're doing, how you're coming along.
Okay, so that'll be a status date, and then I'll be notified of the next appearance after that.
Yes, you will be brought back whenever the doctor says you're ready to come back. And I'm just checking on you on January 13th, so you may not be here that day. I'm just going to check to make sure that you're getting the services that you need.
Okay.
That's all I'm doing.
Hey, that's fine. Hey,
Yeah.
it's a step down the road. Okay, so I'm
Yes.
going to go to the hospital, and
Yep.
what would be the next court dates?
After that?
Appearance, like, like first appearance,
Yeah.
plea day, arraignment, docket?
Yes.
What would that court date be called?
You'd be back for another hearing for me to pronounce that you have been restored to competency, and that's going to happen whenever the doctor that's going to be treating you says that you're ready, and they'll send a notice, and we will set you as quickly as we can after that.
Okay, and that'll be a hearing when?
We don't know.
When would possible trial be?
Well, we got to get through this process first.
Okay, so
Can't set it
we're
until-
going to the mental competency still.
Yes,
Okay,
yes.
just getting a bearing and getting an
Absolutely.
understanding of where I stand with the court system and where the entire case is going, just so that I
Yes.
know and I can be on the same page with y'all.
I understand that completely, sir. So we've got to get through this process. I'm not able to, under the law, I cannot set your trial until we get through this process.
Okay,
First.
okay, by law, okay,
Yes.
hey, excellent, hey, that's what I'm trying to
Yeah.
keep the law too.
Yeah.
Okay, hey, then I will see y'all
Yes.
back whenever I see you.
I'm looking forward to seeing you back, sir, and then we can proceed with your case at that time, okay?
Excellent, that sounds good.
Thank
Judge
you.
Clark, have a good day.
You too, sir. Thank you.
Schaffner's up next.
Judge, this is Rayshawn Schaffner. He's before the court on 21 CF 2362, 21 CF 2364, 21 CF 2399, 21 CF 3297, 21 CF 3299, 22 CF 340, 23 CF 1155, 23 CF 1156, 23 CF 1205, 24 CF 2408, and 24 CF 2049. Judge, the court may be aware that Dr. McDonald did file a report. Although Mr. Schaffner did not meet with her, she indicated that based on the information she had available, that she was determining that he was competent to proceed. Although I'm in disagreement with that finding, I don't have any legal basis to object to it at this moment. I think that's a couple things need to occur. I think we need to place Mr. Schaffner back on the regular docket if we can move him back to the December pretrial. Additionally, I think that Mr. Schaffner, before this occurred, he had wanted a Nelson hearing. So I think that if we can set this for a Nelson hearing date in November, I don't want to overload the miscellaneous docket. I'm aware that there are people already, a lot of people on that docket, but
Let me check a couple of things. So, first of all, good morning, Mr. Schaffner. It's nice to see you again, sir. I did receive, or I saw the report from Dr. McDonald. It was filed yesterday. I think it was only, well, I didn't check every single case, but I saw that it's in at least 24 CF 2049, but I didn't see it in some of the other cases. Are the attorneys stipulating I can rely on the contents of the report rather than bring in Dr. McDonald to testify?
yes, for that
Yes,
purpose,
Your
Judge,
Honor.
yes.
Okay. And what about with Dr. Zeman's previous report?
If that's been previously filed, I think she might have incorporated it by reference in her report, but, yeah, I have no basis to object to that, Judge.
Okay, state, can I
Yes,
rely
Your
on
Honor,
Dr.
same with the
Zeman?
state, no objection.
All right, I'm relying on both reports. Dr. McDonald's most recent report, it was filed yesterday, October 20th, and then Dr. Zeman's report, I don't have the date it was filed in front of me, but it's been a while. But I did review both reports, and I'm finding that Mr. Schaffner is competent to proceed based on those reports. So I have an order. And Mr. Schaffner, this is what we've been waiting on for me to enter this order, so now we can proceed with your cases. We've been on hold, waiting for this report to be completed. Everything was paused, waiting for that. Now we can start moving forward again. So I'm entering the order now. So now let's schedule, first of all, in all of the cases, we need to schedule the pretrial conference. That would be December the 10th at 9 o'clock in all cases. And Mr. Schaffner, let me pull up one of your cases and take a look. I do need to ask you some questions to figure out what I need to do next, okay? I know we had a Nelson hearing. We had one on April the 10th, 2025. I entered a detailed order on that. And then looks like there was another motion filed on May 1st. And then I think there was another one filed. September 18th, 2025. Okay, so, Mr. Schaffner, would you like me to go ahead and schedule those for a hearing?
For what hearing?
Nelson hearing.
A Nelson hearing? You're wanting to discharge your court-appointed counsel, is that right?
Yes, ma'am.
Okay, so I need to set a hearing on that because you did file a couple of motions that have not been scheduled yet. So let me look and see what we have on Thursday.
If I can get the hearing and actually come to court and get rid of the attorney instead of, coming out here for no reason.
Okay. Well, we'll have to have the hearing and see how that goes. I'm just trying to find you a hearing date. It looks like we could probably do this on Thursday morning.
I'm fine with that. State's okay with that?
Yes, Your Honor.
Okay, that's October 23rd. That way we can go ahead and get that taken care of, that hearing, and start moving forward with resolving the cases. So October 23rd, that's this Thursday, 2 days from now, okay? At 9 o'clock. And I'll address your motions in there where you're asking to discharge your current counsel and have different counsel appointed, okay? So you definitely need to come to court that day, okay? And let me ask the state, now that we're able to proceed with all of the cases, where does the state stand as far as which one you're proceeding on first?
Your Honor, the state would not be able to give an answer at this very moment. The
Okay.
state has reviewed all of these cases, just not sure which one would go on first.
Okay.
But definitely by pretrial, that will be figured out.
Okay. Well, then, Mr. Schaffner, I'll see you Thursday, October 23rd at 9, and we'll address those motions that you filed, okay?
Right, sir.
Thank you.
Thank you, Judge. That's all I have this morning.
Okay. Thank you, Mr. Harper, very much.
Can I take one out of custody real quick?
Yes.
This is going to be Mr. Willie Kimball.
Okay.
He's before the court in 22 CF 607 and 22 CF 652. All morning long, I've been trying to figure out how to get this restitution paid that's outstanding, Your Honor. We've run into a couple roadblocks. After talking with the state, I think the plan is to continue the hearing. He's going to get a hold of JCS. In the meantime, we're going to get a hold of JCS, and then we may end up filing a memo allowing restitution to be paid through the clerk's office, and that should resolve that outstanding issue, which will let us enter an issue at that point.
Okay, what's the state's position?
That is correct, Your Honor. It looks like the outstanding restitution is in 22 CF 607. Once we can figure out how to get that paid, and once we figure out the exact amount owed, the state will file a restitution memo with the clerk so we can move forward and get this over with.
All right. So were you asking for the November 18th date?
Yes, Your Honor.
Okay. That would be November 18th at 9 o'clock.
Sooner you get paid, sooner we get a result.
In both cases, 22 CF 607, 22 CF 652.
Thank you,
sir. All right, Ms. Farkas, Mr. Medina, and Mr. Gates, I would like to take care of the people who are in the courtroom before we break for lunch, if possible. So I'm not sure who all is present in the courtroom of your clients.
Your Honor, I have one client in the courtroom. We may have to continue her case. Dawn D. Byers. Ms. Byers is approaching. 22 CF 1606 and 23 CF 341. She's out gainfully employed, doing pretty good, and we needed to determine what the state's position is. But if the state needs some more time, that does not seem to me to be a problem to do a short continuance, because it seems like she's trying pretty hard and making some progress.
Your Honor, the state is dismissing the VOP. It looks like the sole basis was a new law violation and a misdemeanor battery that was dismissed as well. So
That's correct. That's the most salient point, which I had told the state, but that I forgot to mention to the court. Thank you.
All right, ma'am, your affidavit of violation of probation has been dismissed, so you're just continuing on probation. So you need to continue to check in and follow all the requirements.
All right.
Thank you, ma'am.
Take care. Thank you, Your Honor.
Thank you. All right, and I see multiple people still in the courtroom.
I know, Your Honor, I'm sorry, I know a few of them are family members,
Okay.
a couple of my incarcerated clients.
Let me handle it this way. If you have a case yourself on today's docket and you have not already been called up to the podium I'd like to go ahead and call your case now so that you don't have to come back after lunch. So anyone who has a pending case today, if you could come on up and line up at the podium so we can try to help you get on your way. Yes, ma'am, if you could tell me your name.
My name is Tiffany Taylor.
All right, let me find your case on my docket. Do you have an attorney?
No, I don't.
Okay, let me find your case. Could you give me a case number, please?
2020 CF 001819F.
1809? Okay. let me just-
1819, Your Honor.
1819. Thank you. Let me look up that case. Yes. I see an order to appear that was entered on September the 8th, 2025. And the allegations are failing to make restitution and failing to complete this community service work. And I see, ma'am, that you don't have a lawyer. Would you like me to appoint one?
Yes, ma'am.
I'm appointing the Office of the Public Defender.
Your Honor, if I could inquire about an offer from the state, it looks like the offer from probation, given that the outstanding issues are just essentially the restitution, probation recommended that the restitution be sent to a civil lien and the probation be terminated.
Yes, Your Honor, probation recommends that the probation term be unsuccessfully terminated and the cause sent to judgment, and that would be the state's.
And I believe that her probation, her term of probation expired on October 14th as well.
Okay. What about the community service? Just,
We would just unsuccessfully terminate, Your Honor, so it would not be completed.
okay. All right, ma'am, so that's what the state is requesting to do. Is that, Ms. Farkas, do you?
Your Honor, I would recommend if, just as a friend of the court, if Ms. Taylor would like to avail herself of that offer, that the court unappoint the public defender so she doesn't have to pay a public defender fee.
Okay. So, ma'am, what's being discussed is the balance of your restitution going to a civil lien?
Yes, ma'am.
Okay, and then your probation will be terminated unsuccessfully. So, is that what you wish to do?
Yes, ma'am.
Okay. So, and let me check with Officer Prophet. Yes, it looks like termination was last week, or was the scheduled termination date. All right, so at this point, the court will consider probation unsuccessfully terminated, and all outstanding financials will be going to collections and/or a lien. And any other findings that I need to make from the state?
No, Your Honor.
Anything else you need, Officer Prophet? All right. Thank you, ma'am. You are free to go.
Thank you.
All right. We're just terminating and sending everything to them. So everyone else who's in the courtroom, you do not have a pending case, you're here as a family member or victim or in some capacity other than as a defendant, is that right? Just making sure I'm not missing anyone that's in the courtroom. Okay, so it's 11:37, we have time for a few cases before we break for lunch. I'll leave it to the attorneys as to who they wish to call first.
We have one more attorney. Let me just get one.
While we're waiting, is Cedric Hill present? Cedric Hill, 23 CF 600. All right, I will recall Mr. Hill at the end of the docket.
Your Honor, on Cedric Hill, it appears that he wasn't properly notified of this hearing today.
Okay. All right.
Hello,
Good morning, I'm Judge Clark. Can you tell me your name?
Christopher Clester.
Yes, thank you. I believe Ms. Farkas,
I was previously assigned to Mr. Custer's case. I don't think that we've been assigned yet, but if you would like an attorney, then.
all right.
Yes.
So, Mr. Clester, I'm Judge Clark. You're here on allegations that you violated your probation
Yes, ma'am.
in 24 CF 2759. There was an affidavit filed on September the 15th, 2025. Right now, it doesn't appear you have an attorney. Would you like me to appoint one?
Yes, ma'am. And I have a question. Would the state have an offer, like, right now for it?
Your Honor, if I may.
I'm appointing the Office of the
Thank
Public
you.
Defender.
I was just reading the probation recommendation and briefly spoke with Ms. Gaynor. It looks like they're recommending perhaps mental health court. So what I would request is, I'd advise him to enter a denial today. I'll come see him at the jail and have him, we'll look into mental health court and I'll talk to the state about it, if we could put him on the November date.
All right. That would be November 18th at 9 o'clock.
I was hoping it could get reinstated, but there was some dumb, like, misunderstanding.
So I'll come see you at the jail, okay? Thank you.
All right.
Your Honor, I filed the order for a competency evaluation. I believe that Your Honor signed it.
Yes, I did.
So I think we put this court date just in case Mr. Karstoffner filed for a Nelson hearing, but given that the order has been filed, I do think that kind of puts a stay on the case just generally.
Yes, so I think we were set for that possibility, but good morning, sir. We're here in case 25 CF 1684. I did enter the order appointing Dr. McDonald. I entered that order on September 17th, or I'm sorry, October 17th. So I've appointed a doctor to come see you at the jail to see if there are some services.
The state attorney requested.
I'm not incompetent.
Okay.
The state attorney requested it.
What I need a doctor for, I don't take no
Well,
medication.
the state attorney requested it. Once they raise the issue, I have to appoint the doctor, and we're on hold
A
until
doctor
that.
for,
Yes, for competency
I
evaluation.
don't need no doctor for that.
Okay, well, I gotta wait and see what the doctor says. I'm on hold until
That's what I'm
then.
saying. I don't even take medication. What's the reason for that?
So I need you to cooperate when the doctor
Honey,
comes to see you.
I've been coming to this courthouse since '05.
Right, so
I completed. mental
when
health
the
court
doctor
through this
comes
month.
to
I'm saying,
see you,
what's
I need
the
you to
doctor-
cooperate with her because that'll move things along faster. I know you want to get things resolved. So when she comes to see you at the jail, you need to cooperate with her evaluation.
For a misdemeanor?
It's a felony charge.
You're
and the
charged with a
doctor is just-
felony.
Criminal mischief in the court of law has always been a misdemeanor. I don't know
Thank
where
you,
y'all-
sir.
So Pensacola,
Right,
they're
this way, sir.
they're
Thank you, sir.
misdemeanor in Pensacola and they're felony here.
Thank you, sir.
Okay, I get that
All
one.
right, thank you.
Get that one. Judge Simon said misdemeanor. You said-
Thank you, sir. All right, let's set Mr. Karstoffner. I think he's set for December the 10th.
Yes.
So we'll call that pre-trial conference, but it's probably going to be a competency status because I can't proceed with pre-trial until competency's
Yes,
taken
ma'am.
care of.
This is Sean Chapman.
Okay?
Grab my files.
All right, this is 2020 CF 292. And Mr. Chaplin, I'm Judge Clark. Good morning, sir.
Morning.
You're here on allegations that you violated your probation. There was an affidavit filed on July 30th, 2025. The allegation, there's one, and it's that there was an unsuccessful discharge from Phoenix House. So, Ms. Farkas, how do you all wish to
Yes, Your Honor.
proceed?
I've spoken with Ms. Gaynor about this case fairly extensively. We're coming to an agreement. If we could have a continuation to the November date, I believe that Ms. Gaynor is planning to set an evidentiary hearing in December if we're unable to reach a resolution at the November date, which Mr. Chaplin is aware of.
Okay. So we will schedule Mr. Chaplin for November 18th at 9. Okay? Thank you.
Your Honor, do you have, I know yesterday we spoke about some December dates for a
I do.
DMP. Can we go ahead and get that? Or do I need to reach out to Ms. Bailey to do that?
If you wouldn't mind reaching out to Ms.
That's no
Bailey,
problem.
I have multiple dates the first week of November, so we can get that in that week, okay?
Thank you.
Sure, thank you.
And next up is Nathan Crowder, 24 CF 1476 and 24 CF 2648. The state and the defense have reached an agreement in this case. I just need to have my client sign it.
All right.
Okay, you're good. Just so you know. You what? The time above. If I may.
Yes.
And the score sheet is there as well.
Thank you so much. This appears to be a downward departure. Is this a legitimate, uncoerced plea bargain?
Yes, it is, Your Honor.
Correct, Your Honor.
Okay, thank you.
I'm going to give a copy to probation.
All right, sir, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down if you'll state your name, please.
Nathan Eric Crowder, ma'am.
Thank you. In 24 CF 1476 and 24 CF 2648, it's alleged you violated your probation. There was an affidavit filed on July 17th, 2025. It had 3 allegations of violation of probation. Have you had a chance to talk to your lawyer about those allegations and any possible defenses?
Yes, Your Honor.
All right, have you discussed this agreement with your lawyer?
Yes, Your Honor.
Did you read and sign the agreement?
Yes, Your Honor.
Is that your signature on the back page?
Yes, Your Honor.
Do you understand you're giving up your right to have a contested hearing and make the state prove the allegations?
Yes, Your Honor.
Are you entering the admission freely and voluntarily?
Yes, Your Honor.
Is anyone forcing you or threatening you?
No, ma'am.
Has anyone promised you anything other than what's showing on the agreement?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, Your Honor.
Are you admitting all three of the allegations in the affidavit filed on July 17th, 2025?
Yes, Your Honor.
I accept your admission. I find it was freely and voluntarily entered. And in both cases, looks like there was a previous adjudication of guilt. So probation will be revoked and terminated in both cases. And in each case, you will be sentenced to 11 months and 29 days in the Okaloosa County Jail. It looks like that's on count 1 in each case, concurrent with credit for time served. And then in case 24 CF 1476, there will be, this is in addition to previously imposed fees and costs, there is a $150 cost of defense fee, that includes the application fee, and a $100 cost of prosecution fee. In 24 CF 2648, there's a $100 cost of defense fee and a $100 cost of prosecution fee. You will have 24 months after you get out of jail to pay all of your outstanding fees and costs before they go to collections. Did I cover everything, Ms. Farkas?
Yes, Your Honor.
All right, so sir, good luck to you. You have 30 days to appeal the order of the court. If you can't afford a lawyer, I'll appoint one for you. Good luck, sir.
Thank you, Your Honor.
Thank you.
Thank you.
Good luck, sir. Your Honor, next up is Prentice Fagan.
Okay. That is 24 CF 2951, and Mr. Fagan is present.
Yes, he is. The state and the defense have reached an agreement in this case. I just need to have my client sign it.
Okay. Good morning, Mr. Fagan.
How you doing, Ms. Clark?
Okay.
How many days did you say? No.
To do.
Okay, thank you.
A little bit easier. All right. If I may approach?
Yes.
This was a plea to a misdemeanor, so there's no score sheet required.
Thank you. All right, Mr. Fagan, if you'll just raise your right hand, do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, sir. You can put your hand down. If you'll just state your name for me, please.
Prentice Lamar Fagan.
Thank you. In case 24 CF 2951, it's alleged that you violated your probation. There was an affidavit filed on September 5th, 2025. It had one allegation in it. Have you had a chance to talk to your lawyer about that one allegation you violated your probation and any possible defenses?
Yes, ma'am.
All right, have you discussed the plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
It is.
All right. Do you understand you're giving up your right to have a contested hearing and make the state prove that allegation against you?
Yes, ma'am.
Are you entering the admission freely and voluntarily today?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Are you satisfied with the services of your lawyer?
I am.
Are you admitting the one allegation that you violated your probation?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily entered. In accordance with your agreement, there was a previous adjudication of guilt on the underlying misdemeanor charge. Your probation will be revoked and terminated, and you will be sentenced to 90 days in the Okaloosa County Jail with credit for all time served. I seem to remember that Mr. Fagan has a lot of credit.
Not actually that much. We'll have to do just under 2 more weeks.
Okay, well,
So
You're
most of it's
almost
done,
there.
yes.
You're
I'm good
almost
with that. Yes, ma'am. Thank you.
You're almost there. All right. So 90 days jail with credit for time served. And in addition to any previously imposed costs and fees, the following additional VOP costs are imposed. $150 cost of defense. That includes the $50 application fee and a $100 cost of prosecution fee. You will have 24 months after you get out of jail to pay all of your outstanding court costs and fees before they go to collections.
Yes, ma'am.
You have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you, sir.
Yes, ma'am.
Thank you.
Ladies and gentlemen, take care.
Your Honor, if I could approach,
Yes.
I do not know why Mr. Ferguson was transported from Walton County Jail. But, yeah. This is a case, can we approach?
Yes, Mr. Ferguson is present. This is 22 CF 17 and 22 CF 258.
Yeah, just take that.
All right. Mr. Ferguson is present, 22 CF 17 and 22 CF 258. And we are resetting, we're continuing the cases and resetting them for November 18th at 9 o'clock. And I'm ordering that Mr. Ferguson be taken back to the Walton County Jail. I had signed an order for him to be housed there. Walton. He needs to go back to the Walton County Jail. That's where he's being held.
Thank you. This is Eric Salazar, 2019 CF 2238. This is the first VOP date up. We have an offer from the state attorney. It's from Mr. Sprouse. I need a little more time to speak with him, and as he's not present, we'd like to enter a denial today and request the November 18th court date.
All right, and good morning, sir. I'm Judge Clark. You are here on allegations that you violated your probation, and I looked at the file. It looks like there was an amended affidavit filed on August 26, 2024 that had 3 allegations. Hopefully that's the most current one. So
yes, that's what I have.
We will set Mr. Salazar for November 18th at 9 o'clock, and Ms. Farkas will be out to talk to you, okay? Thank you.
Thank you.
She's mine. Lori Sen. The female. If you want to bring her, no worries.
Okay. I do have a question
Oh, yes.
regarding Mr. Ferguson.
Yes.
He's going back to Walton, but what about his appearance on November 18th? Do you want him transported or not?
Not sure yet. I will communicate with Deputy Rominger, or, I'll communicate with Transport. If we do not want him transported, I will make sure that they know
Okay.
not to bring him, and if we do, then I'll make sure to file an order to transport him.
So he should be brought unless you tell him not to, or he should not be
He
brought?
should not be brought unless I say otherwise, unless we need him here. The presumption will be that he should not be transported.
Okay, so he's not to come unless there's an order, yes.
Yes. That will be easiest because it likely will not be resolving then either, so.
Okay.
And we'll definitely be on top of an order to transport if we need him here, so.
Okay. All right, and what case are we?
Yes, Your Honor, I'm sorry, this is Lori Sen. I believe that she's under Mr. Gates's name, but she's my client.
Yes, that would be.
SENN 24 CF 2306.
Yes.
The state and the defense have reached an agreement in this case. I just need to have Ms. Sen sign it.
Okay.
There you go. Right there. If I may approach.
Yes. Thank you so much.
And I'm providing a copy to probation as well. Correct. Yes. So it's only on count 2. Misdemeanor. Yeah. You've got some real. Yes. Yeah.
So we are reinstating and modifying then?
Yes, Your Honor,
Okay.
we're doing the little magic trick to maintain the withhold of adjudication in count 1, the felony count. So she'll be reinstated with the special condition of 120 days jail.
Okay.
And then it'll terminate immediately upon release. Count 2 is the misdemeanor count, and there will be an adjudication of guilt on that count.
Okay. All right, ma'am, if you'll please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth? If so, say, "I do."
I do.
Thank you, ma'am. You can put your hand down. If you'll just tell me your name, please.
Lori Sen.
Thank you. In 24 CF 2306, it's alleged that you violated your probation. Looks like there was an affidavit filed on May 23rd, 2025, and it had 2 allegations that you violated your probation. Have you had a chance to talk to your lawyer about the allegations and any possible defenses you might have?
Yes, ma'am.
All right, have you discussed this plea agreement with your lawyer?
Yes, ma'am.
Did you read and sign the agreement?
Yes, ma'am.
Is that your signature on the last page?
Yes, ma'am.
Do you understand you're giving up your right to have a contested hearing and make the state prove the allegations?
Yes, ma'am.
Are you admitting the violations freely and voluntarily today?
Yes, ma'am.
Is anyone forcing you or threatening you?
No, ma'am.
Are you satisfied with the services of your lawyer?
Yes, ma'am.
I accept your admission. I find it was freely and voluntarily given, and in accordance with your agreement. As to count 1, the court will continue to withhold adjudication. Probation is going to be reinstated but modified as follows. You will be placed on a new term of 120 days of probation with a special condition that you serve 120 days in the Okaloosa County Jail with credit for time served. And probation will automatically terminate upon your release from jail after you have served that whatever that turns out to be with your credit factored in after the 120 days. And then as to count 2, it was a previous withhold adjudication, that's the misdemeanor. There will be now an adjudication of guilt on that misdemeanor charge on count 2, and the same sentence. We are reinstating, but we are modifying your probation. You'll be sentenced to a new term of 120 days of probation with a special condition that you serve 120 days in the Okaloosa County Jail with credit for time served, and probation will automatically terminate upon your release from jail. And that's, both counts are concurrent. And let's see, $150 cost of defense. That includes the application fee of $50 and $100 cost of prosecution. Those are in addition to any previously imposed costs and fees. And you'll have 24 months after you get out of jail to pay all of your outstanding financial obligations in this case. Did I cover everything?
Yes, Your Honor.
All
And I
right.
provided a copy to probation as well.
And you'll have 30 days to appeal the order of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you, ma'am. Thank you. Thank you. Sure.
Your Honor, I just have one quick one to address. It's an out-of-custody client.
Okay.
Erica Cook, C-O-O-K.
All right.
23 CF 2487.
Okay, 23 CF 2487, Erica Cook, okay. I have it down that today was going to be a plea, and I do not see Ms. Cook present. Okay.
She is not present, Your Honor. I do not have a record to make, unfortunately.
She has missed the last couple of court dates.
And
I know
with
there-
those, I was in contact with her.
Yes, there were reasons for those.
Yes.
Okay.
I believe that Ms. Basso was going to be asking for a KPS.
Yes, Your Honor, the state would ask for a KPS.
Okay.
Your Honor, I would just ask, given that I have previously been in contact with her and that the intent was to reinstate the probation, and I've been in contact with Ms. Basso about it, that the KPS be a hold for first appearance as opposed to a no bond KPS. If Your Honor would consider that. I know the court is not inclined to do so on a VOP, but we were prepared to resolve it in a way that wouldn't be keeping her at the jail.
Okay.
And she does have a young son, and has sole custody of him, and he's quite ill.
Okay. Could I see Deputy Torres really quickly? I'm just looking up something on Ms. Cook's case.
Oh, yes, Your Honor.
So Ms. Cook is already here and before the court on a previous amended affidavit that was issued back in October of 2024 with 7 allegations. And she was given a stipulated bond back in May after she was arrested because I understand about her family situation. That was
Yes,
why there
Your
was a
Honor.
stipulation between the parties to set bond at an ROR. Then there was another allegation filed, and I issued a warrant on that one.
Yes, I was just made aware.
Yes, so that's outstanding. There was a new allegation, so. So what I'm going to do is just, I mean, she's got a warrant already for the new allegation of an additional violation.
Yes.
I'm also going to issue a capias for today for failing to appear. And she's, right now, the warrant on the VOP is in no bond.
Yes, Your Honor.
So, I mean, what is the state requesting on this capias?
Your Honor, the state requests no bond.
That's what the court is going to do, since I've already done it on the other allegation. And if there's a resolution or a stipulation, then of
Yes.
course we'll cross that bridge when we come
Yes,
to it.
as
But
soon
for
as she
now,
gets picked up, we'll handle it.
Yeah.
Thank you, Your Honor. I believe that is
Sure.
all of my cases.
Okay?
I'm just going to take a quick one, Mr. Gates. Since I'm
Yes.
sitting in the office by you. I asked the booking deputy if he's not here.
Hey, all right, so Abiel Gonzalez Valle for the court in 24 CF 1297.
Yes.
I met with Mr. Gonzalez yesterday, and his preference is to try and basically resolve the new law misdemeanor that's pending before we resolve the VOP. You want to go agree to that? Your Honor, he's indicated there is an offer he wants to take. If we can bring him back after lunch and resolve it that way.
Sure, let's do that. All right, we'll call you back up after
Here's
lunch.
your copy. I'll talk to you before they bring him back out, okay?
And this is 24 CF 1297.
Give him a copy of the plea agreement real quick,
Okay.
Your Honor.
All right.
That's the terms. All right. And then we'll see him after lunch, Your Honor.
All right, thank you. So it is 12:09. Let's go ahead and, well, I know there are people. Oh, okay. To the family of the previous defendant, I'm sorry, we were trying to get the case taken care of before lunch. I know you're here waiting on that case, but there are some legal matters Mr. Gates is going to discuss, and we're going to recall that case after lunch. Okay? So we're going to take our lunch break now, and let's come back in 1 hour. I have 12:10 as the time, so we'll be back at 1:10. All right.
All right,
Thank
please.
you.